like everybody is connected or almost connected. Okay, this is Concierge Corrections versus Berrien County Jail et al. Docket number 22-108CB. This is the time set for hearing on the defendant's motion for summary disposition. And before we begin, I'll take appearances of the attorneys. Please, plaintiff first.
Yes, Your Honor, this is Attorney Jessica Schultze appearing on behalf of the plaintiff, Correctional Recovery.
Dennis Egan and Matthew Derby appearing on behalf of the defendants.
Melissa White, I'm the plaintiff.
Thaddeus Ackworth, counsel for Berrien County.
Okay. And this is the defendant's motion.
Correct, Your Honor.
Okay, go right ahead, sir.
Yeah, Your Honor, the complaint has 3 counts and defendants have brought a motion to dismiss all 3 of them. The first count is for breach of contract. Now, part of it we think is easy. I understand everybody always says that, but they have sued the Berrien County Jail as an entity. Now, it's a building, it's not a separate entity. But if you look at Exhibit A, which is the contracted issue, it has 3 parties: the plaintiff, the County of Berrien, which is a legal entity and is a defendant, and the sheriff, which is a person and a legal entity and a defendant. The jail is not a defendant or not a party to the agreement. Now, they pointed out there's an Exhibit B attached, which mentions the jail and not really signed by the jail as a party, but that's not the agreement they claim is breached. So first of all, the jail should be dismissed because it's not a party to the alleged agreement and therefore could not have breached it. Secondly, under 2.11b, and I understand this is unusual in a breach of contract case, but this complaint's unusual. We are entitled under the court rule to be put on notice of the nature of the claims that they're bringing. And as we set forth in our motion and brief, they have pleaded in some detail the circumstances of the signing of this agreement that's at issue. They have also discussed at some length what happened after they claimed it was breached. In other words, some back and forth between the parties. But if you look, for example, at paragraph 14 of the complaint, it pleads that they're entitled to be paid 37% of, quote, reimbursed medical claims and 37% of reduced medical claims. The next paragraph is defendants owe $730,511. We don't know what portion of that is for reimbursed claims. We don't know what portion of it is for reduced medical claims, or is it something else entirely? They essentially have attached this somewhat complicated agreement to the complaint and expect the defendants in the court to peruse and parse it to try to figure out what supposedly the defendants did wrong, rather than pleading, you know, we ordered 100 bushels of tomatoes. The defendant didn't deliver 100 bushels of tomatoes on the date in question, and we had to buy them somewhere else. So it's unusual, but I think in fact they don't state a claim for breach of contract in a manner that complies with Rule 2.111B, which requires enough facts to be pleaded to put us on notice. The second count is for unjust enrichment. Now, I think they even agree, we don't dispute, people can plead unjust enrichment as an alternative to a complaint on a written agreement, but everybody agrees you can't recover for an unjust enrichment theory where there's a written express contract on the topic. The difference here is they are claiming that they were unjustly enriched. We were unjustly enriched because we breached this contract, the written agreement. For example, paragraph 37 pleads that the defendants have the amounts due and owed to the plaintiff under the terms of the agreement. And those are the funds by which they claim the defendants were unjustly enriched. And we cited the Elia Companies case, 335 Mishap 439. You can't bring an unjust enrichment claim that's premised on the breach of a written agreement, which theirs is. So we believe count 2 has to go because you can't bring an unjust enrichment claim not only where there's a written agreement, but where your complaint expressly premises the unjust enrichment on the defendant breaching the contract and therefore holding the money that they would seek as damages in the case. The third one, count 3, is for fraud. Now, we have 2 reasons for dismissal here. First, the easy one is fraud has to be pleaded with specificity under the court rules. They make generic statements of, quote, misrepresentations, but under the case law, the defendants are entitled to know the who, what, where, when, who said what. These are the misrepresentations were made on these dates by these people. There's nothing here at all specific. It just said misrepresentations were made and it's the cause of damages to the plaintiff. Under the court rules, that's not enough. But number 2, there's a pretty thorough and longstanding body of case law in Michigan that you can't premise a tort claim based on a breach of contract. In other words, there's no such thing as the negligent breach of a contract or the fraudulent breach of contract. If you've got a contract, you can't then bring a tort claim based on duties that flow from the contract. Here, everything they're complaining about is based on an alleged breach of this agreement with the county, the written contract, and you can't premise a fraud claim based on the breach of contract, and they don't dispute the case law that we cite on the fact that Michigan doesn't allow essentially tort-based actions in contract cases. So accordingly, we believe all 3 counts should be dismissed.
All right, thank you. Ms. Schultz?
Yes, thank you, Your Honor. Attorney Jessica Schultz appearing for the plaintiff. As to opposing counsel's motion, the first breach of contract claim moved to dismiss should be denied because of the 2 reasons that they have alleged that there were issues with it. One, that because of the defendant Berrien County Jail being named, and 2, because plaintiff has failed to provide a final amount of its ever-growing damages. Neither argument is supported by the facts or the law. In this case, it's obviously a question of fact as to whether Berrien County Jail is a party to the agreement, and in our position it is. The county commissioner actually did sign on behalf of Berrien County Jail the business associate agreement, which is incorporated into the agreement at issue here. It is the basis for which my client actually can conduct the services she provides under HIPAA and high tech, according to the health privacy laws. That was the first agreement that was executed on behalf of the county, the jail, and the sheriff to begin the negotiations for the contract that's at issue. The other argument as to not informing Berrien County as to the nature of the claims, an amount has been provided, and in previous correspondence with the defendants, reconciliation reports to this amount have been provided. However, again, it is an interest-bearing amount that is due and owing, and we are happy to provide detailed information during discovery in that area. There is the plaintiff's argument underneath paragraph 31 of the complaint, where we allege that they breached the argument based upon amounts due and owing for the inmate healthcare services provided, and that is the amount that is alleged under count 1. The second count that they wish to have removed is pled in the alternative, and that is the argument for unjust enrichment. If defendants are willing to stipulate that there is in fact an agreement here and a contract as to count 1, then we would agree that we could stipulate to having this claim removed. But at this point in time, plaintiff or defendants are alleging that there is no count 1, therefore no contract or breach of contract at issue and a dismissal of. And in this case, we would plead in the alternative if that were not the case. It's also ignoring the fact that defendant's response really didn't address the matter of the breach. So again, if we would have affirmatively addressed the breach of contract and that the agreement is enforceable, we would agree then that the unjust enrichment claim could be dismissed. Because defendants have not done so yet, the claim should certainly be denied. Finally, as to count 3 and the Hail Mary effort at our claim for fraud and or misrepresentation, we would argue again that the contract would be on point. The fraud claims are not related to the contract, nor what plaintiff has alleged. The fraud claims are not related to the contract, nor is that what plaintiff alleged in the complaint. As stated in paragraphs 42 to 49 of the complaint, defendants made statements that have intended to resolve and reconcile the amounts it owed to plaintiff and failed to do so. This conversation continued for some time. In reliance of defendants' representations and promises to pay, plaintiff continued to work during the period of March and April of believing that defendants would honor their obligations, but instead they deceptively terminated the agreement without notice to plaintiff and induced plaintiff to perform additional work and process inmate claims for the entire month past the time defendant actually terminated the agreement with the county board. The complaint provides the proper notice, therefore the court should deny this motion, and we request and award attorney's fees to the plaintiff in responding to this motion, which clearly ignores the allegations as stated in the complaint. Thank you.
If I may respond, Your Honor, and I'll be quick.
It's rebuttal time.
Yes, on the breach of contract claim, they said the jail is a party to this business associate agreement, which is a separate agreement. But if you read the complaint itself, it's all based on breaches of Section 4 and Section 6 of the other agreement, which is the asset recovery agreement. The jail is not a party. There's no claim anywhere in this complaint that the business associate agreement was breached. It's the other agreement that the jail is not a party to. So the mere fact that this agreement is out there, this is based on the pleadings brought by the plaintiff, not what else they think might be out there. She said that it's a question of fact as to whether the jail is a party. This is not a C-10 motion where whether there's material questions of fact exist, whether that's the basis. This is based on the pleadings. It's a C-8 motion. So saying there's a question of fact isn't a response. The contract, that issue, this recovery agreement, doesn't show the jail as being a party. Regarding the 2.111, she said, our argument is that they haven't given us a final amount of damages. That's not the argument at all. They pleaded $730,000 and odd dollars as damages. I want to know how we get there. I want to know what they're saying we didn't do that we were supposed to do. It has nothing to do with whether they have a final amount of damages issued or not. Their number is out there. We don't understand how they got to that number. and we think the deficiency is in the pleadings. Regarding count 2, they don't plead it in the alternative, unjust enrichment. The unjust enrichment relates to dollars they're claiming they should have gotten under the written agreement. And count 2 pleads the written agreement, essentially. It's right there. So it's not pleaded as an alternative. As in the Elia Company's case, it's premised on the written agreement, not as an alternative. And the fraud claims, it's not a Hail Mary, at least as the nuns at Resurrection School explained to me in my younger years. It's not a Hail Mary at all. They don't plead with specificity. For example, paragraph 42. Defendants made material misrepresentations to plaintiff regarding its intent to timely and properly resolve and reconcile the amounts due and owing under the agreement. That's general. Who made the representation? Who did they make it to? On what day did they make it? It's not satisfying the requirements of specificity to say the misrepresentation here. 43, defendants made material misrepresentations to plaintiff regarding the term of the agreement. Okay, who said what on what date? The court rules very specific. It has to be pleaded with specificity. This generalized, there's misrepresentations out there, doesn't satisfy the requirements of the rule. And Your Honor, there's no more basis for imposition of attorney's fees in Rule 2.116 than there was for her request to have us be ordered to answer this complaint in 7 days if you happen to deny the motion. Because the time in the court rules, rule 21 days, not 7. So I'm going to ask that our motion be granted. And thank you very much for working us into your schedule.
Thank you. First of all, with respect to the breach of contract claim and the naming of the Berrien County Jail, the defendants say in the C8 motion, which is brought as a first responsive pleading, that the jail is a building and not a party to this agreement that is being sued upon, and I thoroughly agree with that. The Berrien County Jail is a building. There is a separate agreement called business associate contract between the plaintiff and what is described as the Berrien County Jail. The jail being a building, they couldn't sign. It's the chair of the Board of Commissioners that signed, but that is a separate agreement. It appears to cover HIPAA or privacy issues. It has no monetary obligations in it, and the complaint is not alleging any violation of the business associate contract. Again, the complaint only alleges monetary damages and a breach of the asset recovery agreement, asset recovery and management services agreement, pardon me. It does not make any allegations that would fall under the business associate contract, which again has no even monetary obligations in it. For those reasons, I am dismissing the so-called Berrien County Jail as a named party defendant to this lawsuit. The defendants also complain about the adequacy of the pleading of breach of contract, but in that respect, I disagree with the defendants. I won't read all of the paragraphs, but of course I've read the complaint. And I think that paragraphs 13, 14, 15, 18, 19, 23, 26, 32, and 34 all adequately describe for notice pleading purposes what the plaintiffs are maintaining is a breach of the contract. Although the defendants deny that they're requiring a computation of damages, it sounds to me like that is their complaint, that there's no showing of a calculation of damages, but that's something that can be dealt with through discovery. But for notice pleading, the breach of contract claim, I believe, is adequately pled. So although I'm dismissing the Berrien County Jail, I am not dismissing the breach of contract as to the remaining defendants. Next, the defendants say that the unjust enrichment claim is based on an express contract. And of course, the law is well settled that if there is an actual express contract, you cannot have a unjust enrichment claim. Plaintiff's arguments here today seem to be a little bit at odds to me with the complaint and what they're alleging in the complaint. Because as I read the complaint, what they're saying is that there may be a period of time where the contract was terminated, but the plaintiff continued to perform services. And if in fact there should be a ruling or a factual development that the contract was in fact terminated, then the plaintiff would be due under unjust enrichment for the services that they rendered when there was no longer a contract in place. Now that makes sense to me if that's the allegation, which it appears that it is, and that is not a theory based on an express contract. It's just the opposite. There's no longer any contract. We're still providing services. Perhaps what they're doing is, and counsel for defendants mentioned this, that there's a damage calculation under the contract, but that's a damage calculation that they're alleging. It doesn't mean that they're claiming a breach of the contract. For that count of the complaint, they're claiming in fact if there was no contract for this period of time because it was terminated, then we are due this amount of money. So I will not at this early stage in the case dismiss the unjust enrichment claim. The last count is the fraud claim. And I agree this is not a Hail Mary at all. The law is very clear on this. First of all, you can't claim tort for breach of a contract. However, having said that, and that's very well settled, I have to say again that it doesn't entirely clearly appear that that's what the complaint is saying, because again, it goes back to, if you read the allegations under the fraud claim, that the plaintiffs, I think, are saying that there was a period of time where they were being told, we're going to pay you, when in fact the contract had been terminated, and they were misled, allegedly, I think they're saying, into believing that they were proceeding under a contract that in fact was no longer in place, and representations were being made about that, making that they relied on allowing them to go forward and perform the services when in fact there was no contract. So if that's the case, there wouldn't be a tort based on breach of a contract. It would be a separate period of time where there was no contract. However, the bigger problem is, and this is again not a Hail Mary, this is well established, fraud has to be pled with specificity. And I totally agree, the fraud claim is very vague, very general. It does not meet the specificity requirements. The specificity requirements would require that a time, place, and content of the fraudulent statements be pled in the complaint. So for failure to plead with specificity, I would grant the defendant's motion to dismiss the fraud claim. And then finally, in its reply, the defendants make the statement that the plaintiff does not read the court rules, and I would like to comment on that. First of all, there's no basis to award plaintiff attorney fees in this motion. Second of all, this is a first responsive pleading. If it is denied, then the answer must be served 21 days after. So in fact, the defendants have 21 days. And another matter I would like to address is that MCR 2.116G provides that unless a different period is set by the court, a response must be filed at least 7 days before the hearing. The defendant's response to this motion was filed on Monday. This hearing was set for yesterday. That was 2 days before the hearing. It was adjourned to today because of a conflict with my schedule, but the response was filed 2 days before the hearing. It's clear to me that the defendants had it earlier than that, because the defendants filed a reply on the very same day that I received and the day that the response of the defendants or the plaintiffs was filed. So on the 9th, not only did the plaintiffs file their response to this motion, but the defendants filed their reply. So obviously the defendants had the response before it was filed and before I had a judge's copy. That's inconsiderate to the court, and it's a violation of the court rules. I am entitled to have a filed response at least 7 days before the hearing. And I would just point that out going forward in the future. I don't care to adjourn matters because of a late response, because it only penalizes the moving party, and that's not fair. So the only reasonable way to proceed if this happens going forward is that I will strike an untimely response and I will not consider it. And I would note as well that a judge's copy has to be sent directly to the judge's office. So for all of those reasons, I am granting in part and denying in part the defendant's motion under C8. And Mr. Egan, if you would prepare a 7-day order and submit that, I would appreciate it.
I will do that, Your Honor.
Thank you very much. That will conclude our hearing.
Thank you.
Thank you.
Thank you.